going to call to order the Judiciary Finance and Policy Committee. Today is Tuesday, March 18th. We have the first bill on the agenda is House File 3015. Members, this bill has multiple clones, and so my motion is that it will be re-referred to Ways and Means. It is my intention, members, that we are going to finish this agenda so we don't have to come back at 5. So I may put some limits on some testimony and things if members will bear with us. All right. Representative Carlson, welcome to the committee. Please come to the table, bring your testifiers, and I will move that House File 3015 be recommended to pass, just be re-referred to Ways and Means. Representative Carlson.
Thank you, Madam Chair. And with me are the potential testifiers, and if need be, we have some others in the audience to answer questions. I think basically Russ Stanton will testify, and Nicole Listenbach is available for questions, Madam Chair. This bill, House File 3015, would create the Public Employees Relations Board under the Bureau of Mediation Services. And the board would handle unfair labor practice charges listed in PELRA administratively rather than going into the courts. And Minnesota is one of the very few states that if you have an unfair labor practice, the issue needs to be resolved in the courts. The vast majority of the states do it through a process of going through the Bureau of Mediation Services. They do it administratively. And it costs much less if you use an administrative process than if you use a process where you utilize the courts. And we'll have a couple of examples of the differences in the costs. So what we do is we create a 3-member board. The members would come from one of the public employee unions. Another would come from the employment side. Both would be appointed by the governor. And a third person is chosen by the other 2. So that would create the 3-member board. We do have in the amendment that's before you to the bill, it surfaced that, well, what if there were a conflict of interest on either side? And so what we've done then is changed or proposed a change with the amendment that would allow for people to serve. If there were a conflict, they would be there to fill in instead, and there would be one appointed for each one of those 3 positions that would be designated as alternates. So, Madam Chair, that's the bill in a very brief overview. It's supported by AFSCME, Council 5 and 65, Education Minnesota, MAPE, Middle Management Association, the Minnesota State College Faculty, Interfaculty Organizations, Teamsters Local 320, SEIU, Minnesota Association of Administrative and Service Faculty. And I would only point out all the unions that they reference there are public employee unions. And there is another separate process under the law for private sector employees. So that's why this one is so designated. So, Madam Chair, the rest of the amendment that's before you, and I basically explained the gist of it, is technical as recommended by staff. So I will stop there, but I'm not sure if you want to adopt the amendment now or later, but I basically explained the bill and the amendment.
So I will move the A14 amendment to get the bill in the shape that the author would like it. All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Representative Carlson, to your testifier.
Madam Chair, members, my name is Russ Stanton. I'm Director of Government Relations for the Interfaculty Organization, which is the union for the faculty at the 7 state universities. I'm speaking in favor of the bill. This legislation was initiated by the Interfaculty Organization, but because it involved PELRA, we contacted all of the other unions, and we discovered that all of the unions are very strongly in support of this. Education Minnesota, AFSCME, MAPE, SEIU, et cetera. What the bill does in layperson's terms is allows unfair labor practices to be processed administratively rather than through the district courts as they now are. And the reason we want that is it's far less expensive and far less time consuming to use an administrative process to resolve disputes. In the administrative process, you do not have to have attorneys, and you're dealing with people that process it administratively that have a background in labor law, and so they tend to produce quicker, better decisions, in our opinion. It's not unusual when someone brings unfair labor charge through the court system to cost $50,000 to $75,000, and it can take a year or two. It's very cumbersome. It can cost even more if it goes through trial. On the other hand, in the private sector, where unfair labor claims are processed through the National Labor Relations Board, it typically costs about $5,000 to process a claim. There's 35 states that have unfair labor practice statutes, and only 3 of them use the courts: Minnesota, Arkansas, and Texas. The other 32 use an administrative process like this. And all of our surrounding states, Wisconsin, Michigan, South Dakota, Iowa, all use the administrative body. None of them use the courts. Keep in mind that unfair labor practices can be brought by, or charges can be brought by the employer, they can be brought by the employee, they can be brought by an individual, by the union or by an individual. And reducing the cost and streamlining the process helps everybody, but who it helps the most are small unions or individuals who just don't have the resources to use the courts. Unfair labor practices are not very common. In the 28 years that I've been with IFO, we've had one. We spent about $50,000, went to court. They said, "You're right, now go back," and they ordered the employer to bargain in good faith. It's an extremely expensive process. In terms of total cases, I mean, I'm sure you look at the effects on the courts. Only one charge was brought last year, or processed, a complaint. 5 in 2013, 9 in 2012, 5 in 2011. So it's not a huge number that are processed. So we think this is a very common sense bill. It'll save people money. It'll allow individuals and small organizations to get some justice if they have been treated wrongly. And we'd urge your adoption of the bill.
Thank you. Questions from members. Representative Drazkowski. Now, remember, members, that the only reason this bill is before us is because we're giving up the court's jurisdiction. Currently, these cases are handled in the court system. They would be in an administrative process going forward. Representative Drazkowski.
Thank you, Madam Chair. Well, Madam Chair, a question: does this bill also have a fiscal impact, and does that relate to the parameters of this committee?
Representative Drazkowski, we are checking to see if there would be a fiscal impact to the court, but it would make it cheaper here, and we do not cover the expenses of the administrative side. So any fiscal impact would be a savings to the court. Representative Drazkowski.
Thank you, Madam Chair. But in order, as a member of this committee and as a member of the legislature, to properly address, we need to really look at both sides of this. What is it going to do to the court, and what kind of new costs are going to accrue to the taxpayers of Minnesota? So I hope, Madam Chair, that line of questioning is germane. I would, the first thing, Madam Chair, I'm wondering if Mr. Stanton would again review those numbers of complaints and what the estimated costs of those complaints have been in total for each of those years.
Mr. Stanton.
Madam Chair and Representative Drazkowski, the number of filings in 2014 so far is 1, 2013 5, 2012 9, 2011 5. I mean, that goes back a few years. In terms of cost in the courts, I don't know. In terms of the costs, I mean, I'm only familiar with the cost to the employee groups in two cases. One would be ours, which was about $50,000. Another was with Minnesota State College faculty who brought a complaint. It cost the union about $61,000. It took about 15 months, and they finally settled before final judgment. So that gives you some idea of the cost. I couldn't speak to what it costs the courts. That's not my area of knowledge.
Representative Drazkowski, I just consulted with fiscal staff. If you want to give us any indication about any fiscal savings or any information you might have. Mr. Walz.
Madam Chair and Representative Drazkowski, while it's true this bill could save the court some time on complaints that would go to mediation services instead, unless the workload that is reduced by this bill is enough to eliminate a judgeship and support staff, it would not save the courts money. When we recognize the savings in the courts, it's by eliminating staff that hear those cases. They have contended in the past that they would perhaps like more staff to deal with the caseloads, and this might allow them to better handle cases that are before them in the different jurisdictions. But unless we eliminate a judicial position or some support staff, it doesn't save the state any money.
Representative Drazkowski.
Thank you, Madam Chair, and thank you, Mr. Walz. So I've got some notes here that suggest that this fiscal impact of this bill to the general fund is $125,000. That's in the bill? Okay. So that's for fiscal year 2015. So biennially, we're looking at $250,000. I would suspect that that takes care of a judgeship and probably at least some staff. I don't know what that covers, but it seems like a lot of money.
Representative Carlson.
That 125 is for the rulemaking. That would be a one-time expenditure for the rulemaking process. That was addressed. In fact, you were on the committee, Representative Drazkowski, when it was before government op. We talked about the rulemaking, and that's the purpose of the 125.
And Representative Carlson, if you would talk into your microphone, because this is on TV. Thank you.
I didn't realize it wasn't close.
That's
Want me
okay.
to repeat it?
Why don't you go ahead?
Oh, I was saying the 125 is for the rulemaking process, so that would be a one-time expenditure. I think what Representative Drazkowski was assuming was that would be carrying forward for the biennium, but once the rules are adopted, that would be the total cost that's in the bill at this point.
Mr. Walz.
Madam Chair?
Mr. Walz has also got a response. Mr. Walz.
Madam Chair and Representative Carlson, on the A14 amendment on page 11, at the top of the page, under Minnesota State, I'm sorry, it just says this appropriation is added to the base, so I believe the intent is to make this permanent. However, if this is used for compensation of board members and for per diems, any money that goes unused at the end of the biennium cancels back to the general fund.
Well, yeah, Madam Chair, the per diem reimbursement is the same as for any other board. The board members would serve without salary, and I should remember the exact number, but I think it's roughly $55 a day that a board member would receive per diem.
Thank you, Representative Carlson. Representative Drazkowski.
Thank you, Madam Chair. So, Mr. Walz, so what we have right now are the best, what will show up on the spreadsheet, what will show up in the next biennium to the base, will it be $250,000?
Mr. Walz.
Madam Chair, Representative Drazkowski, I believe that's correct.
Representative Drazkowski.
Thank you, Madam Chair. So the concern is, again, $250,000 to move forward with, again, another board that will displace activity in the courts that seems to be rare at best, and we don't have really the courts costs. That would be the other part of this fiscal puzzle that it would make sense for us to have here today. But this is really concerning to me, Madam Chair. I'm wondering, another part of the bill, well, Madam Chair, that doesn't fit within your guidelines, but I would just offer, and Representative Carlson and I had discussion in front of Government Ops too, that the concerted activity, it would help to have some definition of that in the bill, and we still don't see that. That's all I have, Madam Chair, and I would suggest, Madam Chair, that we lay this bill over till we have the rest of the fiscal data before we move forward.
Representative Johnson.
Madam Chair, going along with what Representative Rakowski was talking about, working at the bill under Section 5, I don't think it's going to be any impact on relieve any impact on the courts, because all these decisions can be appealed to the appellate court. So it's going to more than likely end up back in the court system the way this bill is written right now.
Thank you. Representative Scott.
Well, that was part of my line of thinking, too, and it just seems to me that we're shifting the burden of paying for these cases from, if there's one a year and you pay $71,000, what's the cost to the unions going to be if this happens? Are we just shifting the cost from, you guys to the state, or how's this working?
Representative Carlson.
Well, Madam Chair, I would only point out that the potential savings to the unions or the individual, it isn't always necessarily a union that brings the unfair labor practice, I think is fairly clear. I think the average was about $5,000 versus the $50,000 or $60,000 that was referenced. But there's another important point with this, and that's that this is much faster and much more efficient. You get your answer, at least when this process is used in the 30-some other states, you get the answer to the question of the unfair labor practice much faster. Otherwise, it takes sometimes months or even years before it's resolved in the courts. So I think if we only focus on the savings, we're only seeing part of the question, and I don't know if either of the people that are at the table would like to comment beyond that. While I'm speaking on the appropriation is added to the base, actually this appropriation is going to be addressed tomorrow in the Labor Committee. That's where the Bureau of Mediation Services is before, and I have a hearing. I've actually got 2 hearings on this bill tomorrow. So we'll have further discussion on that. I was told that the approximate cost for the rulemaking was $125. I perceive that as a one-time expenditure, so I'll explore that further, and we'll make whatever final adjustments necessary either tomorrow night or tomorrow morning, whichever it is, in that committee or in Ways and Means.
Thank you, Representative Carlson. Is there anyone in the audience who wishes to testify for or against this bill? All right. Seeing none, are there any other questions from members? Representative Scott.
I just had a follow-up question. I see Representative Johnson is here. Is the Labor Committee a fiscal committee? Is it a budget committee, or is it just a policy? I'm not sure. I don't know.
Representative Johnson.
Thank you, Madam Chair. It's a policy committee.
So wouldn't, Madam Chair,
Representative Scott.
thank you, wouldn't this be the committee to discuss the fiscal issues? And why wouldn't we have a copy of that fiscal note here?
Representative Scott, the fiscal issues that we would discuss are fiscal issues related to the judiciary. The judiciary has said unless we eliminate a position, it doesn't have a fiscal impact. And so any of the fiscal concerns would be in a different committee, and ultimately will end up in the Ways and Means Committee as well, which is Representative Carlson's committee.
Madam Chair, if I may, I
Representative
misspoke.
Carlson.
It's not the Labor Committee that's the fiscal part. It's Representative Mahoney's Jobs Committee is the other. I said it's going to be before 2 committees tomorrow, and that's the one that will deal with the appropriation, not Labor.
Thank you.
This is going through so many committees, it gets a little confusing which one's doing what.
Right. Thank you. Well, welcome to the committee. State your name for the record and go ahead.
Madam Chair, members of the committee, I'm Julie Blau, Legislative Director for AFSCME Council 5, and I'll be brief. Mr. Stanton indicated the reasons of support for this bill. We'd like to go on record supporting the bill before you. It reduces legal costs. It will expedite and provide for better speed, and also enables enforcement of the law. Thank you.
Thank you. Welcome to the committee. State your name for the record and go ahead.
Sure. Madam Chair, members of the committee, my name is John Thorson with Education Minnesota, and not to say the same thing 3 times for the reasons that were brought up by Mr. Stanton and Julie Blyle, the cost, expediency, and also the expertise that can be built through an administrative process specific to these charges are the reasons that we'd support this. Thank you.
Thank you. Other questions from members?
Madam Chair?
Representative Drazkowski.
Is BMS here? I'm curious as to how this fits into their workload as they come forward.
Anyone here?
Wondering.
I see no one here.
So, Madam Chair, the Bureau of Mediation Services, who this would impact directly, is not here today.
They are not, and they are not within the jurisdiction of this committee.
Well, they certainly, this is an intricate bill that connects the courts and the functions with BMS. Certainly the appeals have some direct connection there. I just find it somewhat fascinating that the agency isn't here to talk about a bill that directly impacts them. I'm still not sure, Madam Chair, why a fiscal note was not requested on this bill. It seems standard operating procedure that a bill that has known fiscal impact will have a fiscal note or a revenue note in those cases with them. We don't have either here.
Representative Drazkowski, I make a commitment to you that as fiscal notes are taken care of and requested through the process, if there is a fiscal impact to the committee, we'll talk about it.
So, Madam
Representative
Chair,
Drazkowski.
So, Madam Chair, if we will learn what the courts will save and how that will relate to the cost of the bill, and so you're saying if we have the ability to know those 2 pieces of information through that, we'll bring the bill back here?
Representative Drazkowski, I will commit to you that if there is a fiscal savings to the court or a fiscal cost to the court, we will address that. We will potentially have a budget bill between now and the end of session. If there's something that we have to address, we will. Representative Drazkowski.
Thank you, Madam Chair. Lastly, I'd ask for a roll call on this unnecessary bill.
Representative Drazkowski requests a roll call. The clerk will take the roll. Yep.
Representative Hillstrom?
Aye.
Representative Moline?
Aye.
Representative Drazkowski?
No.
Representative Bly?
Aye.
Representative Cornish?
Aye.
Representative Hortman?
Aye.
Representative Johnson B?
No.
Representative Johnson S?
Yes.
Representative Lesh?
Aye.
Representative Leine?
Aye.
Representative O'Neill?
No.
Representative Paymar? Representative Pugh?
No.
Representative Scott?
No.
There being 9 in favor and 5 opposed, the motion prevails. Thank you, Representative Carlson.
Well, thank you, Madam Chair and members of the committee.
The next bill on the calendar is Representative Simonson. Is he here? Representative Simonson, welcome to the committee. Representative Simonson, the chair will move that House File 2446 be re-referred to the Health and Human Services Finance Committee. It's my understanding that you have a DE1 amendment. Is that the amendment you'd like to have offered?
Yes,
DE1?
Madam Chair, that would get it in the shape that I'd like to have it in.
The chair will move the DE1 amendment to get the bill in the shape the author would like it. All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Representative Simonson, please go ahead.
Thank you, Madam Chair. Before I get into the pertinent sections of the bill, I'm wondering if you would entertain a oral amendment. We've got one word in a number of places throughout the bill that I'd like to change.
Representative Simonson, go ahead.
The word is, the first one would be on line 1.12, right behind where it says Minnesota law, where you see the word that should say and rather than that. And that same change, is on line 4.2.
If I could stop you for just 1 second.
Yep.
Does the comma need to go? Does the comma stay? Okay. I just wanted to make sure the comma stayed or whether the comma went.
Okay.
So, Representative Simonson, go ahead.
So the remaining changes are the same changes on line 4.2, 4.16, and 5.26.
Questions from members? Members have that? Staff have that? All right. The chair would move that oral amendment to get the bill in the shape the author would like it. All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Representative Simonson.
Thank you, Madam Chair, committee members, and I'll keep my comments brief. This is the synthetic drug bill that we've been working on over the interim with the select committee that the Speaker appointed at the end of last session. As a result of several listening sessions across the state and taking of testimony from victims, victims' families, law enforcement, public health institutions, the Select Committee came up with a report that was presented in February. Within that report are a number of recommendations to statutory changes to try to accomplish two main goals. One would be to stop the retail sales of synthetic drugs across Minnesota, hopefully to the extent that we've created something that can't be gotten around by the manufacturers, and two, to provide a additional educational component targeting middle school, high school, and college-age students. The particular sections of the bill, Madam Chair, that I think that you're most interested in would be under Section 2, Subdivision 1A, which creates the cease and desist order process for the Board of Pharmacy. And I do have with me here today Dr. Cody Weiberg from the Board of Pharmacy to talk about what this would mean and how he would interpret it and enforce it. Before I turn it over to him, I would just say that the language that you see here, which reflects the cease and desist order process, is not necessarily new. It's primarily modeled after what's in current law in Chapter 45 under Commerce. So with that, Madam Chair, I'd like to turn it over to Dr. Weiberg.
Welcome to the committee. State your name for the record and go ahead.
Madam Chair, members of the committee, I'm Dr. Cody Weiberg. I'm the Executive Director of the Minnesota Board of Pharmacy. And the language that Representative Simonson is talking about concerning cease and desist order is actually language that largely comes from the Attorney General's office. The Attorney General became very interested in this issue and held a hearing up in Duluth. She actually invited me up there to participate. The testimony was both riveting and portions of it horrifying about the effects of these drugs on the city of Duluth and the citizens there. As Representative Simonson has mentioned, this language is modeled after language that the Department of Commerce has, and the way that we envision that it would work. First of all, we've changed the definition of drug to make it crystal clear that the products that these folks are selling are drugs. The reason why that's important is the Board of Pharmacy for decades really has had the authority to take action whenever anyone sells misbranded or adulterated drugs. Those are drugs that are either not labeled correctly or not manufactured correctly, so that they're a danger to the citizens. And so if it comes to the board's attention that an establishment is selling these products, the board would have the authority then to issue a cease and desist order, basically telling them they needed to stop selling the product, and that the business then would have the opportunity, well, actually we'd have to hold a hearing before an administrative law judge, and then the business would have the opportunity to go to court to show that the board should not have taken that action. During this process, the board also has, for a very long time, had the authority to go into any establishment in the state from which drugs are sold and to get samples of products. So we envision that we would get samples of these products and have them analyzed to confirm that they're in fact drugs before we would issue the cease and desist order.
Thank you. So, members, the real reason why this proposal is before us, if you're looking at the DE1 amendment, you can see that on line 2.21 it talks about the appellate judicial review, You can also see that on line 3.7 and 3.8, it talks about bringing an action in Ramsey County Court. And finally, the section that is on line 7, starting on line 7.31, it talks about the court ordering a person convicted of selling these controlled substance some mandatory restitution. Those are really the reasons this proposal is here. So, Representative Johnson.
Madam Chair, Representative Simonson, I want to thank you for putting in the restitution that was talked about in the public safety. I think that was important. Then I have another question. It talks about bringing the action in Ramsey District Court. I believe that's on the appeal process on the cease and desist order. Now, if you have an incident that happens up in, say, Coochin County, which is not in the Ramsey County District Court area, would somebody from, if the cease and desist order was put on somebody that in the business up in Coochin County, would they have to drive all the way down to St. Paul in order to provide this? And so they'd have to come down to court in Ramsey County when discussing this? Shouldn't it be in the district court where the incident occurs?
Representative Simonson.
Madam Chair, Representative, that's a great question, and we had a lot of discussion about that, and we essentially decided that rather than change it, we would just follow the practice that's in the current law in Chapter 45, and that's what is in there.
Representative Johnson, a follow-up?
And Madam Chair, Dr. Weiberg may have a comment.
Dr. Weiberg.
Yeah, Madam Chair, Representative Johnson. Actually, I discussed this language with the Assistant Attorney General that was assigned to develop the language, and what I was told is that it is common or usual that when a state agency like the Board of Pharmacy issues an order like this, that it's the Ramsey County Court that hears that case.
Thank you. Other questions from members? Representative Lesh.
Thank you, Madam Chair. And I'm trying to recall my involvement when this came through public safety. But I cannot figure out why we would remove the legislature's determination of what is a drug and what isn't a drug and completely outsource it to the Board of Pharmacy. Can you either tell me or remind me of why this body is not fit to oversee the rulemaking that the Board of Pharmacy does in its determination?
Representative Simonson.
Thank you, Madam Chair. Representative Lesh, I won't go so far as to say that we're not worthy of doing that. I think that what we're trying to do here is simplify the process. Current law, as you know, requires that if the Board of Pharmacy, during the time that the legislature is not in session, adds a particular drug to Schedule 1, let's say they have that expedited rulemaking process in current law. And the law goes on to state that if it's not ratified by the legislature in the subsequent session, that would expire. We're suggesting, based on the research that the committee has done, that there's really no reason for that. We rely on the Board of Pharmacy to do that work, and we depend on the work that they do, and we still retain the authority to change anything at any time. It just doesn't, what we're proposing here is to strike that reaffirmation, if you will.
Can you, Madam Chair, Representative Simonson, can you remind me, did this question come up in public safety when this bill went through public safety?
Representative Simonson.
Madam Chair, Representative Lesh, I honestly don't remember. I know the question has come up in some committee. I just don't remember which committee.
Okay. Well, Madam Chair,
Representative Lesh.
I've complained about this from time to time, as I think members in this committee are aware of, that it's the legislature that decides what's illegal to do and what's not illegal to do around here, and we only outsource that job to agency rulemaking when it is necessary. And I would think that the determination of what is actually on the streets poisoning our kids or actually helpful to folks generally is definitely the province of legislative committee. And right now we're saying, well, you know what, with a wink and a nod, we're sure that the Board of Pharmacy is doing a great job of making that determination. We're just going to skip over that part. I don't think we should be doing that. I absolutely don't think we should be doing that. I think that the legislature should be reviewing, especially with respect to your entire reason for this is because the speed at which drugs are being adulterated on the street, which I think is all the more reason of why these committees should be reviewing exactly what the Board of Pharmacy is doing. So I don't support this bill with that language in it, and I want it out of there, essentially.
Representative Laine. Use your mic, please.
Madam Chair and Representative Simonson or Mr. Weiberg, I'm just wondering, sort of along those lines of the Board of Pharmacy being able to add a substance to a certain schedule, is the board able to remove a certain substance from a schedule, and what is the process surrounding that?
Representative Simonson.
Madam Chair, I'm going to let Dr. Weiberg answer that.
Dr. Weiberg.
Madam Chair and Representative Laine and Lesh, if I could actually explain the whole process, I think it might clarify some things. First of all, the board's authority to make changes to the controlled substance schedules actually dates back to the early 1970s. In 1970, 1971, the Federal Controlled Substance Act was enacted, and just about all of the states then designated some sort of state agency to have the equivalent role at the state level that the Drug Enforcement Administration has at the federal level, which is to add things to the schedules, subtract things from the schedules, and so forth. What I would point out is not all of the board's authority is addressed in this bill, or the requirements that are on the board. So at any time when any agency engages in any sort of rulemaking process, the chairs and the ranking minority members of the relevant committees do have to be notified, and the agency has to prepare what's called a statement of need and reasonableness. And all of this is reviewed actually by the administrative law judge in the Office of Administrative Hearings. When it comes specifically to the controlled substance schedules, the legislature has put in other subdivisions, one of which requires the board to review the changes that have been made at the federal level, and actually the DEA makes the changes in consultation with the Food and Drug Administration, and to actually conform the state schedules with the federal schedules. In addition to that, and this is a subdivision that was added just probably 3 or 4 years ago, every December the Board of Pharmacy has to issue a report again to the relevant chairs and ranking members of the committees about any changes that it has done, so the legislature does know what the board has done and has a chance to not only review it, but one of the problems that was noted is that the schedules that the board was doing in rule were becoming out of sync with the schedules and statute. So there's a process in place now, so the board does come back to the legislature every December with a report on the rulemaking, so the legislature consider what it has done and to do that. Now, in regards to removing schedules, the only another change that was made several years ago is the board cannot remove anything from Schedule 1 unless the federal government has also removed it. And that really is because normally if a state adds something to a schedule and the state law is stricter than the federal law, the state and federal law will not conflict. But if the board were to remove something from the schedules and make it less strict than federal law, there'd be a conflict between federal and state law. And the board came to the legislature to have that authority removed because we did think that if the state of Minnesota, the government of the state of Minnesota was going to be in conflict with federal law, it ought to be the legislature and the governor's office that makes that decision and not the Board of Pharmacy.
Hello, Representative Laine.
No, Madam Chair.
Representative Cornish.
Well, Madam Chair, Representative Simonson, I just want to say I support the bill. I think that if we're looking for cat-like speed and reaction time to respond, the last place I would come to is with the legislature. And in fact, the only time we can react quickly is for emergency assistance, and then we have to call a special session. So I think that the best place to go to, and I thought we talked about this quite a bit, in that the reason we depended on the Board of Pharmacy was in rulemaking is to react quickly to the how quickly the the drugs can formulate and a new one come along, and I think we did that with an intent. There's some agencies I don't approve of with granting rulemaking authority, and there's some that I do, but in this one, I approve of that and the bill. So.
Thank you. Other questions from members?
Madam Chair?
Representative Lesh.
I would move that the stricken language on lines 7.21 through 7.29 be reinstated.
Representative Lesh moves that the stricken language on line 7.21 to line 7.29 be reinstated. Questions from members? Representative Portman.
Are you going to ask the author of the bill how he feels about the proposed amendment?
Representative Simonson.
Thank you, Madam Chair. And I would, I would ask committee members to not consider doing that for the simple reason that the Select Committee did a lot of work and a lot of research and had a lot of discussion around this issue, and we feel confident that this provision doesn't necessarily need to continue in statute, but with that being said, respect the position of the committee.
Representative Laine.
Thank you, Madam Chair, and either Representative Simonson or Dr. Weiberg, maybe so you can clear this up for me, as far as the adding of the schedule, I'm just in regards to Representative Lesh's proposal, but if it says high potential for abuse, no currently accepted medical use, how do you determine those things before you would add something to the Schedule 1? I mean, if you decided that e-cigarettes met those conditions, could those be added? I'm just throwing that out there as an example, but I'm just kind of wondering how you establish those to add something to a Schedule 1.
Dr. Weiborg?
Madam Chair, Representative Laine, we do have to do the research to do this. So typically what will happen is, we are the Board of Pharmacy, so our primary focus has been regulating the legal distribution of drugs. So we normally become aware of street drugs, if you will, like this, through contact from law enforcement agencies or county attorneys' offices, and they generally call me directly. Or actually also the Bureau of Criminal Apprehension will also contact us when they have analyzed samples that have been seized and have identified drugs. At that point, we do the research to make sure that these conditions have all been met, and so that involves researching the professional literature to see if cases have been reported where people have been admitted to ERs and the drug's been identified and it has actually caused harm. We take a look at the chemical structure of the product and do some research on the pharmacology to see how it does affect the brain. And again, whenever any agency goes through any sort of rulemaking process, it has to prepare a statement of need and reasonableness, often just abbreviated SONAR. And in that SONAR, we would have to demonstrate that we had evidence sufficient to support the need for the rules. So in this case, we would have to demonstrate that all of these things have been met. In regards to no currently accepted medical use, when we're talking about synthetic designer drugs like this, these drugs have either not been studied in humans at all, or the only studies that may have been done, actually typically they haven't been studied in humans at all, and the only studies that may have been done may have been like in laboratory animals, so there's definitely no accepted medical use.
Representative Driscowski.
Thank you, Madam Chair. Maybe this is for Mr. Weiberg or Representative Simonson, but what form, what track, when the legislature now ratifies the board's actions, as Representative Lesh is looking at reinstating here, when that happens now, which bill does that come in? Is it a normal process or is it an extraordinary measure?
Representative Simonson or Dr. Weiberg?
Madam Chair, Representative Driscowski. It would basically be the board, again, as I mentioned, the board already has to report every December to the legislature about any changes that has been made in rules. And part of that requirement is recommendations for any changes to the statutes that would need to be made. And so I think the bill would typically be developed off of that report with the recommendations for the changes in statutes. I will say, actually, quite frankly, that the suggestion to remove this language actually did come from the Attorney General's office. And for the reasons I stated, I think the legislature is going to have a full report from the board every year at any rate, and could do whatever it wanted to do. But I actually don't see retaining that language as being really, really critical. The legislature, one way or the other, is going to look at what we do.
All right. All those in favor of Representative Lesch's motion to reinstate the language signify by saying aye.
Aye.
All those opposed say no. No. Motion does not prevail. Is there
Division, Madam Chair.
Representative Lesch has requested a division. All of those in favor of reinstating the language, please raise your hand. All those opposed, raise your hand. Motion prevails. Motion fails. I was correct.
I'm going to need to see this. The bill is going to need to stop in civil law, Madam Chair.
The next place it's going to is Health and Human Services. It's going to Health and Human Services Finance next.
One more.
All right. All right. Is there anyone, did I already ask, is there anyone in the audience who wishes to testify for or against the bill? Please come forward. Welcome to the committee. Please state your name for the record and go ahead.
Madam Chair, members of the committee, my name is Curtis Hanna. Thank you for having me today. I wanted to bring up a couple points that I think are very pertinent to your decision today on whether to pass this bill. First off, I don't know if it's just me, but by reading the definition of drug that is listed here, it seems as though it will be any compound, substance, or derivative that is not approved for human consumption by the U.S. FDA. And so, in essence, that's every single substance that exists in the cosmos except for pharmaceutical drugs. And for the FDA, the Food and Drug Administration, for us to say that they are not regulating drugs, it seems like the exact antithesis of what is actually going on. And for the Board of Pharmacy to be able to add any substance to Schedule I or Schedule II in an expedited rule process, and then be able to file cease and desist orders on individuals that have those substances or analogs of those substances, it pretty much undermines the legislature, as Representative Lesch was saying, because it does not have to be a statute for them to issue the cease and desist order. It is any sort of rule that the Board of Pharmacy has. They can issue a cease and desist order. So they don't. It doesn't matter if it's reported to the legislature at the end of the year and then made into a statute. I also wanted to mention regarding Representative Maline's question regarding the removal of substances from Schedule I, I personally petitioned the Board of Pharmacy twice to remove a substance from Schedule I. And instead of passing or going through the proper process of allowing me to go through an administrative law judge to challenge their denial of my petition, they actually lobbied the legislature a couple of years ago and made it so the Board of Pharmacy does not have to remove any substance that is in Schedule I. And I believe that violated my rights as an individual to have due process. And really, I'm coming to you today to petition that you do not let this sort of injustice go on any further. Beyond that, not only are individuals being denied the ability to challenge and have oversight over the Board of Pharmacy and their determinations of what substances are in the Controlled Substance Act. But the expedited rule change process itself denies individuals, and I was an individual that sent a letter to the Board of Pharmacy asking them to have a public hearing when they wanted to have a substance put into Schedule I using rule change process. That is completely denied now because of the expedited rule change process itself, and I very much hope that the language or the amendment that Representative Lesh suggested earlier would prevail in further committees, because this is sort of a travesty of law, and I care about the rule of law, and I care about my civil rights, and I feel like they've been massively violated by the Board of Pharmacy, and this seems kind of like a power play, and I hope that you don't buy into it. I'm open for questions.
Thank you. Representative Scott.
Thank you, Madam Chair. And what was your last name?
Hanna, Hanna.
Okay. Mr. Hanna, doesn't on line 1.12 of the amendment, the change that the bill's author put forth, scratching or crossing out that and adding and, doesn't that make this like, so it doesn't apply to every compound or substance or derivative? I understand what you meant on the first part of what you were getting across, but then it goes on to say that when it's introduced into the body, it induces an effect similar to a Schedule I or II controlled substance. So to me, that eliminates that. Just it could be almost anything.
Yeah, it seems like...
Mr. Hanna, you got to go
my apologies. My
Representative
apologies.
Scott, were you finished?
Yes.
Okay. Mr. Hanna.
And Mrs. Chair, I apologize. I haven't done this very often before. I'm so sorry about that. Yes, it seems like the definition is listed as I stated, and then it says or. Are you saying that there was an amendment to change that to and instead of or?
Representative Scott.
Madam Chair, thank you, Mr. Hanna. Yes, on line 1.12, it was actually the word that, and it was stricken, and the word and was put in after the word, after Minnesota law on the amendment, on the DE amendment. I don't know if you have all those papers. Line 1.12.
All right. While he's looking, Representative Johnson actually has a question as well. Representative Johnson.
Madam Chair, Mr. Hannan.
Thank you.
I'm actually in favor of striking the amendment that Representative Lesh put on, for the simple reason I've actually had contact in my career in law enforcement with the synthetic marijuana. Had a gentleman, had no clue where he was, had no clue what he was doing, lost control of the vehicle he was driving, and just missed an elderly man before he went into the ditch. And we got the call, and it took me about 5 minutes to get there. And this person was still sitting in the vehicle, revving the engine, still thinking he was driving down the road. Because of the current way that drugs are put into the system to make them illegal, at that time synthetic marijuana was not illegal. There was nothing we could do. He almost killed a person. He almost killed himself. The way these drugs are changed so quickly nowadays, before the legislature can even act on them, they might have changed 5 times. That's why we need this expedited process to do this, because the way the current law is minute before we can even get a bill introduced to make something illegal, they've already changed it. And we're 5 steps behind. And in law enforcement and the safety of the public, we can't be 5 steps behind. We have to be ahead of the curve.
Thank you. Representative Scott, did you have a follow-up?
I guess, Madam Chair, I would let him answer the question since I posed it.
Mr. Hanna.
Yeah, it seems to me that the language, as it has been amended, still cedes our state sovereignty to decide what issues should, or what substances ought to be listed in Schedule I or Schedule II. And secondly, because it asks the the FDA to make that decision for us. Secondly, I don't know if you guys have looked at the list of Schedule I and Schedule II substances, but it's alarmingly long, and the complexity of the names is ridiculous. And any substance that has an effect similar to any of those substances are analogs, and those are included in Schedule I and Schedule II. So, if there is now a substance that has a similar effect to an analog of a Schedule I or Schedule II substance, the Board of Pharmacy is trying to make that expedited, or a substance that they can issue a cease and desist order on. So I would be very concerned if I owned an herbalist store or if I owned a hardware store. I believe that probably paint, glue, caffeine, have similar effects to analogs of Schedule I and Schedule II substances. And if the Board of Pharmacy can issue cease and desist orders on these businesses or individuals that are violating a rule of this sort, it seems absolutely absurd.
Thank you. Representative Simonson, any final closing?
Madam Chair, I think the bill speaks for itself, but I want to correct the record. I don't think that owners of hardware stores and legitimate businesses should be concerned. I think that we put provisions in the bill to address exactly what we're trying to target, and I think that stands for itself. So thank you for your time.
With that, the chair renews the motion that that House File 2446, as amended, be re-referred to the Committee on Health and Human Services Finance. All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Thank you, Representative Simonson. Is Representative Laine here? Remember, we have 30 minutes left, and we have 3 bills we're going to try to get through them. Welcome to the committee, Representative Laine. This is House File 2531. It's going to the General Register. It's my understanding that you have an A2 amendment.
Yes, we do.
The chair will move the A2 amendment to get the bill in the shape the author would like it. All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Representative Laine, this is the Judiciary Committee. We're trying to limit as much of the discussion to the section that falls within the committee's jurisdiction. So go ahead.
Okay, I believe that's only regarding section on civil penalties.
Thank you, Representative Laine.
I'll turn it over to my testifier.
Welcome to the committee. State your name for the record and go ahead.
Thank you, Madam Chair. My name is Jeff Sigurdsson. I'm the Assistant Director with the Campaign Finance and Public Disclosure Board. I believe the committee is only going to be interested in Section 6 and Section 7. Section 6 increases the late fee from $5 to $25 a day. Section 7 is a new section. It provides for a late fee and for a civil penalty for committees that do not cooperate, do not respond for a request for information for a reconciliation issue. Reconciliation is when a registered committee gives to another registered committee if there is no response, so that we can figure out why the contributions reported and reported received and reported made don't match. Then currently we have no way to compel those committees to provide us with this information. This provides us with a late fee if they don't do so, and eventually a civil penalty if we never receive a response.
Thank you. There's also one additional section, Section 8. Section 8 on page 5, line 5.26 to line 5.32 actually adds district court judges, appeal court judges, Supreme Court justices to the section.
Madam Chair.
Mr. Sigurd.
This is the economic interest statement. In 2013, the legislature added these positions as to their requirement to file an economic interest statement. However, that provision or that change to the statute didn't provide a very clear schedule as to when they should be filed. All we're doing here in line 5.31 and 5.32 is providing that it's 60 days after assuming office, but the requirement to file the economic interest statement is already existing in statute.
Also, did you already address lines 9.23 to 9.34 where you're deleting the section about an action being brought in district court, Hennepin, or Ramsey County? Mr. Sigurd.
Madam Chair, this provision is primarily was used when a committee has a violation with a contribution issue or with a expenditure issue that they've reported to us. And under current language, it's required that once there's a violation determined basically from the report filed with us, that we would then file an action with the District Court of Ramsey County. when there would be really no need to. In the great majority of cases, there is compliance with the conciliation agreement, the excess contribution, there's a fine for that, excess spending, there's a fine for that. That's paid, and through that conciliation agreement, the matter is closed. There is still the ability of the board in a different section to bring action to Ramsey County if that's not required. That's in, just for your reference, 10A.34 subdivision 2, or subdivision 1A still says that we can go to Ramsey County if there is no cooperation in recovering a fee or a fine imposed by the board.
Thank you. Questions from members? Seeing none, is there anyone in the audience who wishes to testify for or against this bill?
Madam Chair.
Representative Scott.
Thank you, Madam Chair. To the testifier, I noticed that 4.15 through 4.19 is deleted as part of the amendment. Just wanted you to just explain that for the record, please.
Mr. Weiberg. Sorry, wrong testifier. That was the Sigurdson, sorry.
Madam Chair, Representative, I believe you served on that you served in the prayer committee where this bill was heard, and there was a number of concerns raised about whether or not this was ready to go forward. There were questions where it seemed that it would be more appropriate for the board to develop more thorough answers as to how the data would be stored, if there would be any cost related to developing a system that's web-based. So at this point, we would like to draw back on that and develop more information for a future bill.
That was the amendment where we deleted it. Representative Scott.
Thank you, Madam Chair. So what's the plan in the meantime with the data? What are you going to be doing with it?
Mr. Sigurdson.
Madam Chair, Representative, currently, as you recall, the board provides the campaign finance reporter software, which is the free software that your treasurer uses. That software keeps the data on the local personal computer until a report is submitted, and it only submits part of the data that the board is, that 10A provides that the board can receive. So for the time being, basically, that software will stay in place. This was, even this language that has been deleted was only looking at the idea of moving towards a web-based system, and that may still be the solution, but when we come back to the legislature to deal with that issue, we'll have more specific information.
Thank you. Representative Scott, anything further?
Good.
All right. With that, the chair will renew the motion that House File 2531 as amended be sent to the General Register. All those in favor signify by saying aye. Aye. Opposed? Motion carries.
No. Thank you.
Representative Johnson. I believe your bill is going to the General Register. Representative Johnson, is that correct?
Madam Chair, yes, that's correct.
All right. The chair will move that House File 2295 be sent to the General Register. Representative Johnson.
It's out of concern about the safety of victims of domestic violence that I ask for your support for HF 2295 as amended. Last year, 37 Minnesotans lost their lives as a result of domestic violence. 2 of those people lived in my legislative district. In 2011, Minnesota District Courts handled 27,288 domestic violence cases. And in 2010, there were 929 victims of a violation of an order for protection or harassment restraining order. This bill will offer protection to victims of domestic abuse through GPS monitoring, and it builds on a successful pilot project in Ramsey County. The bill will allow that project to continue. It will also allow other judicial districts to convene an advisory group to establish standards to implement similar programs. The group must be comprised of important stakeholders, including crime victim organizations. You can see that on lines 3.2 through to 3.4. The bill establishes state standards, minimum state standards that must be met in any judicial district. You can see the description on lines 3.5 to 3.15. I want you to know that there's intense interest in my area, particularly in Blue Earth County, which has had experienced a large number of domestic violence cases, and that would include the assistant Blue Earth County attorney, Mr. Pat McDermott. I've also spoken with Bradley Walker, the chief judge of the 5th Judicial District. I'll start by introducing John Choi. He's the Ramsey County attorney who will explain the Ramsey County project.
Welcome to the committee. State your name for the record and go ahead.
Thank you, Madam Chair and members of the committee. My name is John Choi. I am the Ramsey County Attorney, and I'm pleased to be here today in support of House File 2295, and I want to first thank Representative Clark Johnson for bringing this issue forward, because this is very critical for Ramsey County, because we've embarked on the pilot program that this legislature actually gave us the authority to start back in the 2010 legislative session. We followed the statute, and we followed what you had suggested at the time, and we started a pilot project to utilize GPS technology in pretrial conditional release situations. And thus far, we've had 28 individuals since its inception, so it's not a lot of people. But we would like to be able to continue on with this program, because the preliminary results are very promising. What we do in Ramsey County is, again, it's for the pretrial conditional release situation. So there's a domestic abuse situation, and as all of you know, domestic violence situations, right when they happen, they're very volatile, they're very unpredictable. And so when a situation occurs and when there is a first appearance, and when the judge is considering appropriate bail and conditions of release, this is an option that is allowed. And so what we do in Ramsey County is Project Remand, which is a nonprofit organization that consists of people in the criminal justice system as part of their board of directors. They are contracted to do an evaluation of the appropriateness of utilizing GPS as a condition of pretrial release. And so we would characterize this as a very voluntary system. First of all, we will never request it from a prosecution perspective unless the victim wishes to have this in place. And if you think about that, a victim who wants GPS technology, and what it would be is an ankle bracelet for the person accused of the crime, and then another device that the victim would have. But typically when someone requests that, they're very fearful for their safety, and so these are very serious situations. And so it's in that context. And then, of course, the defendant, it's also, I guess, voluntary for them, because they really have three options. I mean, one is they could stay in jail pending the resolution of their case. They could pay the full bail amount, or they could agree to this condition of pretrial release, which would be less bail or no bail. And typically what we're trying to do is we're recognizing that we're looking for that intermediate group. We're not looking for high risk, because high risk we would want them to stay in jail from a public safety perspective. But it's that intermediate group that we have to recognize that they're probably going to bail out anyways. And if the victim is fearful for their safety, this is an appropriate tool to utilize the technology that's available to keep victims safe. And the way that we look at it in Ramsey County, and I think across the state, is that whenever we have an opportunity to intervene in these domestic abuse situations, we should look at them as homicide prevention and do everything that we can to keep victims safe. And so we've had great results. The preliminary results are very promising in terms of the ability, or not the ability, but the fact that the individuals come back to court better than the comparison group. Recidivism is another area that we looked at, and the performance there is better. And then also the victims who have been on this technology, they report back. There's been some technical difficulties, but for the most part, they are very pleased with the extra layer of protection that this technology provides. And so with that, Madam Chair and members of the committee, I'll stop there and answer any questions.
Thank you. Is there any other testifiers that you had, Representative Johnson?
No.
Okay. Is there anyone in the audience who wishes to testify for or against this bill? Members, there's really, the real reason that this bill is before this committee is because it talks about the chief judge of a judicial district appointing and convening this group. It also talks about judges being a part of this group, and then on line 3.5 it also talks about requiring a judge to order. And so that's the reason that this is here. Representative Johnson, in Representative Paymar's committee, Public Safety Committee, there was discussion about whether or not there should be some statewide standards rather than minimum standards. And there was some discussion about having discussions about that between that committee and here. Can you give us an update on what your thoughts are on that piece, Representative Johnson?
Thank you, Madam Chair and members. If you look at the bill, there are statewide standards. There's 6 identified minimum standards. Those were carefully developed. We solicited assistance through the Minnesota Battered Women's Coalition, who drew on expertise both through organizations in the state of Minnesota as well as national experts. And informally was shared with us that they think these are actually offer a model for this sort of a set of minimum standards in the state. It's from those standards that the individual judicial districts would operate. Inherently, GPS is inherently a geographical issue. And the geography, both in terms of the physical geography of the various judicial districts and the density of population, inherently demand that the protocols and the standards vary in various parts of the state. So we thought that this was the appropriate way to do that. I'd like to also suggest, and this is something that I feel strongly about, I think domestic violence is a remarkably sensitive topic. It's remarkably challenging. Look at the data. Look at just the sheer human tragedy associated with domestic violence. And that it really demands a community response. A statewide response can be too large. But this bill takes advantage of the opportunities for judicial districts to convene stakeholders, professionals who are inherently working with this population, as well as crime victim organizations, the community, to be involved in trying to address this specific problem. I believe that can build community understanding and community support for addressing domestic violence. I see some some parallels. Try a different word. Some parallels with what we've experienced in my region with specialty courts, where again multiple people throughout the community come together to work in the drug courts, the veterans courts. And I think it's strengthened the response our communities have had that have been working with those courts, and again, dealing with really significant and challenging judicial problems.
Questions from members? Representative Johnson.
Madam Chair, Representative Johnson. Reading through this bill, the way I get it, that the victim would have veto power over the judge ordering GPS monitoring.
Representative Johnson.
Madam Chair and Representative Johnson, yes, the victim would have to agree to it.
Representative Johnson.
Okay, Madam Chair, so Representative Johnson, do you know of any other area of law where the victim has a right to supersede the judge's desires to do something?
Representative Johnson.
Madam Chair, no, I don't. I'm not an attorney, but I do. The point is that's the way this legislation is designed, is to give the defendant that choice.
Representative Johnson.
Madam Chair, Representative Johnson, I guess that's one problem that I see with this bill. I think it would have been better off written where the judge would have the sole authority to put a GPS tracking on a suspect as far as, or a person that's charged waiting trial, and allow the victim to opt in to have the other half of it. There's a lot of times where the victim might report something that they believe that the possible perpetrator might have been involved or at an area, and with the automatic tracking we'd be able to go back and look to see if he would have violated it or stalking the victim in some way. But by having the judge be able to look at the circumstances of the case involved, the background of the possible suspect, he would have the opportunity to decide whether to use it or not, and not have to rely on the victim who might have fear even offering this from the suspect.
Representative Johnson.
Madam Chair and Representative Johnson, I'm just going to beg to differ with this. This is fundamentally a bill to provide security and a sense of safety for the victim. And it absolutely needs to have the support of the victim in the case. And so it's not about the situation you're describing. It's really to provide a situation while awaiting the culmination of the trial that the victim can feel secure. And if there's an issue with proximity, can be alerted to it and can take steps to protect herself or himself.
Representative Lesh.
I just wanted to point out, Madam Chair, that Representative Johnson, the Minnesota Victims' Rights, Chapter 611A, provides for, I count at least 4 of them here, and I'm sure I could count more one in there, that precludes a judge from taking unilateral action without consent from a victim, and I think this is kind of in keeping with that tradition. So Representative Johnson said that he was not aware of an area, but it's not an area he practices in. It is an area that I practice in, so I don't think it's that far out of the scope of what we already do under 611A.
Further questions from members? Seeing none, the chair renews the motion that House File 2295, as amended, be sent to the General Register. All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Thank you, Representative Johnson. Representative Liebling, welcome to the committee. Where does Representative Liebling's bill need to go?
Good afternoon, Madam Chair and members.
Representative Liebling, it's my understanding that your bill is due to go to the General Register next, and I'm going to ask that you attempt to limit the discussion to the areas that have something to do with the judiciary. So Representative Liebling, the chair would move that House File 2545 be sent to be re-referred to the General Register. I think you have an amendment, and that's the A1 amendment, to get the bill in the shape you would like it. And I would move the A1 amendment to get the bill in the shape you would like it. All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Representative Liebling.
Okay, thank you, Madam Chair and members. Members, this is actually a bill from the Board of Pharmacy, so I'm here with Dr. Cody Weiberg, who's the Executive Director of the Board of Pharmacy, and I'm going to let him talk about the bill because this is the Board's bill. I just want to direct your attention to, there are a lot of things in this bill. And one of the, I think Dr. Weiberg will tell you that the Board of Pharmacy regulates both pharmacists and pharmacies. So there's the language in here that I think is within this committee's jurisdiction has to do with cease and desist orders, and it has to do with enforcement of those orders. So I think I will let Dr. Weiberg kind of tell you what he is asking the committee to let the board do.
There's also subdivision 9 that relates to, actually it's section 3, subdivision 9 that relates to evidence and the court administrator. And also section 4, subdivision 4 relates to the courts. I just want to make sure we get the rest of them here. And I think that's all of them. So, welcome to the committee. State your name for the record and go ahead. We're going to try to be done in 9 minutes.
I'll try to be done in 5 or less. Madam Chair, members of the committee, I'm Dr. Cody Weiberg, Executive Director of the Minnesota Board of Pharmacy. As Representative Liebling mentioned, part of the language that's before this committee is actually language that is identical to the language the committee also already heard about with Representative Simonson's bill. The purpose of his delete all amendment was actually to conform the portions of his bill that relate to the Board of Pharmacy in terms of the cease and desist authority with the language in this bill. So that you've already heard about that. I certainly will answer any additional questions you might have. The remaining sections that you mentioned actually have to do with the disciplinary sections of the board's chapter 151. The Board of Pharmacy, like other health licensing boards, licenses healthcare professionals. We also license businesses. And the boards have authority both specifically in the practice acts for each board and more generally in Chapter 214 to investigate complaints received from the public and to take disciplinary action when it's appropriate and necessary. In terms of the Board of Pharmacy, we get about 150 complaints a year from the public, and we pursue about 24 disciplinary cases per year, mostly, almost always, involving pharmacists or technicians who are stealing narcotics or other controlled substances from their employers and using them. On the advice of our Assistant Attorney General over the past couple of years, we were really advised to update the disciplinary portions of our chapter. And in doing some research into the history of those sections, they are, some of them, quite obsolete. And I think this actually fits in with the concept of having an unsession. For just one example, the grounds for discipline in Chapter 151, most of them date from 1941. And so on the advice of our legal counsel, the Attorney General's Office, we have modeled the language that's in here concerning discipline on the language that is used in the Medical Practice Act by the Board of Medical Practice. The Board of Medical Practice, my understanding is the Office of Legislative Auditor looked at their complaint and disciplinary processes several years ago, and there were not any significant findings with their process, which I think is one of the reasons why the Attorney General's Office advised us to actually use the Board of Medical Practice Act as the template when we redesigned the disciplinary sections in Chapter 151.
Questions from members? There's also one additional section in here in the immunity section that just speaks about immunity from civil liability and criminal prosecution on lines 25.28 through 25.31. Any other questions from members? Representative Drazkowski.
Thank you, Madam Chair. I just saw some provisions of Representative Simonson's bill in here. Just a question for the author, is his entire bill in here?
Representative, or Dr. Weiberg.
Madam Chair, Representative Drazkowski, no, it is not. Just the provisions that apply to the Board of Pharmacy. There were provisions there that I think there's an appropriation for, I believe it was the Department of Human Services to do education and prevention and those sort of things. Those were not in here.
Thank you.
Other questions from members? Is there anyone in the audience who wishes to testify for or against this bill? Come to the table. Welcome to the committee. State your name for the record and go ahead.
Madam Chair, members of the committee, my name is Curtis Hanna. I don't want to rehash the issues that I had brought up earlier. I know that you're on a time constraint. I did want to point your attention to line 22.8 regarding mental examinations and access to medical data. It seems like the Board of Pharmacy would be able to get medical records and other records of individuals petitioning in front of the Board of Pharmacy without their consent, and that concerns me greatly as a person that cares about data privacy. And also, they would have to submit to mental examinations as well. And both of these issues are of concern, and I just wanted to bring them to your attention.
Thank you. Questions from members? Representative Lesh.
Thank you, Madam Chair. Mr. Hanna, I didn't get, who are you with?
Mr. Hanna.
I'm a citizen, and I'm currently not with an organization.
Okay.
Representative Lesh.
Well, Madam Chair, thank you. It's good to have smart citizens come in and testify on this stuff. Madam Chair, we're going to need to see this in civil law as well, just for the record.
Representative Lesh, you already did.
Absolutely, Madam Chair. It's come to light that the same provisions as Representative Simon's bill are in there, so the Chair wants to see this in civil law. To paraphrase the words of my former car mechanic, it's good you caught these problems now before they cause you some serious trouble.
And Madam Chair.
Representative Liebling.
Madam Chair, also, I think that some of these, the provisions that have been vetted through the committees of jurisdiction may be carried in my Health and Human Services policy bill. However, that bill is, although the bill was released today, there will be a significant amendment on Friday. And so if there are still issues like the ones that have been flagged here, we can certainly work on those. And they don't have to be in the final product, just so that the committee is aware. This is the Board of Pharmacy's bill. I'm not wedded to any particular pieces of it. Of course, you know, Dr. Weiberg, I think, feels more strongly about some of this probably than I do, but if the chair of the Civil Law Committee has concerns that he is now aware of, I would be more than happy to talk with him and see if we can resolve those.
Representative Lesh.
Madam Chair?
Just Representative Lesh, on 3/6 of 2014, you reported the bill out of your committee.
Thanks for the reminder, Madam Chair. I appreciate that.
Representative Lesh.
And for the record, I have not only recently aired these issues, Representative Liebling, I've been airing these issues for about 2 years. So the fact that if they're coming to light now amidst the 3,500 bills that are have been already dropped this year, I'm glad I caught this now. So I appreciate you working with me on this because I think the concerns raised by Mr. Hanna as well as others here are pretty valid. Thanks.
Representative Laine.
Thank you, Madam Chair. I was just wondering if Dr. Weiberg could address some of those concerns that were just raised by Mr. Hanna regarding the mental examination, mental or physical examination. And I looked at what some of those things would entail under subdivision 214. But my question is, I guess, probable cause is usually a sort of a legal term determined by the courts. I'm wondering, how does the Board of Pharmacy determine probable cause when it comes to whether or not they're going to require a physical or mental evaluation?
Mr. Weiberg.
Madam Chair, Representative Laine, let me give you one concrete example, actually, of an actual case that we had to investigate. We actually do not have a lot of cases that solely, where the allegation is solely that the individual has a mental illness, but we do have them occasionally. And in this particular case, and I can at least speak in general terms, it actually resulted in a disciplinary order, so that part of it at least is public. We had multiple complaints about a pharmacist, both from patients of a particular pharmacy and from healthcare professionals in the town. In that particular case, this pharmacist did have some medical records we could look at, and had in fact been admitted to a crisis unit, so we could actually get those records. However, there certainly could be cases where we have allegations that a pharmacist appears to have problems suggestive of a mental illness where they have actually not seen a psychiatrist or seen a physician and been treated for a mental illness. And so in that case, in a case like that, we would turn it actually over to the Attorney General's office, and they have an investigative division. They would actually look to see if there was some sort of medical records that we could obtain. They typically, in that case, interview the individual, they interview the people that made the complaint, they interview coworkers. And so that's where we would get that sort of information. And again, this is authority already that the Board of Medical Practice has. I believe the Board of Nursing has this sort of authority. It's actually very common with the health licensing boards to have this sort of authority.
Representative Laine.
Thank you, Madam Chair, and maybe Dr. Weiberg or Representative Liebling. Is there another place in law through the Board of Nursing or some other standard where that term probable cause is used? I mean, I don't want to get too hung up on it, but maybe we could just talk about defining that more clearly or changing those words going forward.
Representative Liebling.
Thank you, Madam Chair and members. Representative Laine, that is used in the health licensing statutes, and we're actually doing some other work with that because of some issues that came up with the Board of Nursing, and I have a bill that is going to make some changes for the health professional services program, which is for impaired health professionals. But I think that kind of doesn't get to the entire issue here about that the board is asking for very broad authority here on the medical records issue that I'm not aware that the other boards have or have asked for. I might be wrong about that. And then the requirement to submit to an examination, and then the immunity piece. I can't tell you that other boards have that. I mean, Dr. Weiberg would know that better than I, but the term probable cause is a common term that's used in the context of these health-related boards.
So Representative Liebling, originally, your bill was due to go to the General Register. Clearly, there are some issues that need to be worked on.
Right.
Representative Lesch would like to see it in the Civil Law Committee again, or at least like to speak with you about it. It sounds like there may be some issues that need to be talked about in Health and Human Services, which is your committee. Where would you like your bill sent?
Well, Madam Chair, the idea is to send it to the floor, but it's not going to be taken up on the floor. It's really, the idea is that this, whatever survives, would be put probably in my omnibus bill. So if the committee is not comfortable passing this, maybe, maybe passing it to civil law would not, I don't know if the Civil Law Committee is finished for the year. Might be finished for the year.
Representative Lesch, are you meeting yet this week so this bill could meet deadline and strip out whatever you need to strip out?
Madam Chair, we are still meeting this week. This could be solved with respect to your bill, Representative Liebling, on the same amendment I made on Representative Simonson's bill. If you want to just make that amendment, I wouldn't need to see it.
Representative Liebling, in the provision in Representative Simonson's bill, it strikes language that the action taken by the pharmacy board doesn't need to be ratified by the legislature. And Representative Lesch would like that reinstated so that it would take an act of the legislature. Do you know what page it's on, Representative Lesch?
In Representative Liebling's bill, I do
Yes.
not.
It is on line 51.27 to 51.32.
51.24, Madam Chair.
Oh, 51.24.
If that language was reinstated, I would need to see it.
All the way to 51.32?
That's correct.
We could just delete section
I don't think that gets to the issue.
We could just delete all of Section 20, and it would be from the bill.
Yeah.
Works for me, Madam Chair.
Representative Liebling, would you like to just delete Section 20?
Madam Chair, from my understanding of this, when Representative Simonson's bill was also, I think, heard in my committee, I mean, I guess I'm not, I don't have a stake in the ground on that language, but I don't think it helps with the other issues that the committee's concerned about, frankly. And just to be very frank, as I was preparing, I'm carrying a certain number of bills just for the board and for other, agencies, and as I was preparing for this today, I actually kind of flagged exactly the same issues that the committee brought up. So I have some of the same concerns that I've heard here today, and I would really like to resolve them, but they're not really the one that Representative Lesch is flagging with this amendment. I mean, I don't care, Representative Lesch. If you feel more comfortable taking that out, that's fine with me. Mr. Weiberg, Dr. Weiberg is not objecting. That's fine. But I think there are still other issues that we need to work through a bit more before we move it.
Send it to civil law,
Move
then,
the
Madam
bill.
Chair, I'll give it here.
Otherwise, I was going to say, otherwise we could send it to you, Representative Liebling, and you guys could
Or if you send it,
work that out.
Madam Chair,
Representative Liebling.
if you send it back to my committee, we could certainly handle it that way as well. And I
As
can
Representative
certainly-
Liebling, the majority of the issues that are being raised here, except the striking of Section 20, which we could simply just take out of the entire bill, really are health-related.
Yes, that's correct.
And that's really the proper place to deal with health issues is in the Health Committee.
Yes.
So, Representative Lesch, if we strike Section 20 and send the bill to Representative Liebling's committee, are you fine with that?
I'm okay with that, Madam Chair.
So the chair would move to strike Section 20? Delete Section 20. All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Representative Liebling, then the chair would move that House File 2545 as amended be sent to the Committee on Health and Human Services Policy. All those in favor signify by saying aye. Aye. Opposed? Motion prevails. Thank you, Representative Liebling. This meeting is adjourned.